property. Assume that everybody is here because they want to learn about IP. So this is attorney Lou Svendsen. He is our Tennessee Board of Regents attorney for intellectual property, among other things. And we also have a real quick announcement from Corey. So Corey, if you want to take us off here.
Hi, my name is Corey Stevenson. I'm attempting to start a new organization here at Tech. It's the National Organization for Business and Engineering, and I need at least 15 members to get started. And it's actually, any paperwork's not going to be processed till next semester, but I'm just trying to get members for now. The faculty advisor is Dr. Brian Nagy in the College of Business, and I'd appreciate your support. Thank you.
Yeah, good cause. Thank you, Corey. All right. So with that said, Mr. Lou Svendsen, thank you, everybody.
Thanks. Good afternoon. I like the idea about your engineering and business people. One of the things we find out at all the campuses is that you've got a lot of good scientists between the 6 universities in the system, but we have no way of getting the results, the fruits of their labor, the technology they develop, we have no way of getting it off to the outside world. And we need people who can understand both the engineering or scientifically technical part of the equation and the business equation. So that would be, I think, a good idea. Maybe your club can then, if you get it formed, can go to work and try to get some of the technology around here licensed. As Michael said, I'm the IP lawyer, or at least that's one of the things I do for the Board of Regents, all the Board of Regents schools, and so I'm here to talk to you a little bit today about your rights and responsibilities and anything that you develop, anything you put together. Is my understanding correctly, you're all going to be in a class that's going to be participating in a competition, some sort of, is it a business plan competition, or is it, okay, yeah. And as a result, you're going to be developing products or something of that nature, services, products, so that you can use that as part of the competition. Well, you may find that you like your invention when you're all done, and you want to know who has the rights in it. And I think that's what we're going to talk about today. But let me start off with sort of a disclaimer. No matter what I say here today, I'm not your lawyer, okay? I represent the Board of Regents. I don't represent you. I won't be representing you. So anything I say here is just sort of for informational purposes generally, is not to be taken as legal advice. I have to say all that every time I make one of these presentations. All right, let's talk about the ownership. You want to know if I make it, well, I own it. And of course, the answer you're always going to get from a lawyer is maybe. What are the factors that go into determining the maybe? Well, there's probably more than I'm going to go into today, but let's just go over the ones that I've got here right now. And that is, first of all, can the invention be owned by anyone? We'll talk about that. It's a very hot topic these days. Can the invention be owned by anyone? Secondly, will the law of patents and copyright allow you to claim exclusive rights in your invention or work? We're going to talk a little bit about what it takes to get either a patent or a copyright, and how effective those copyrights or patents may be when it comes to your invention. And finally, we'll talk about the rules or policies of the university. Do those rules and policies allow you to own the invention that you've created here during the period of this competition? So first, let's go into the ownership. And by the way, if you have questions, if there's something that you got to know, please raise your hand, because we can stop and deal with those questions pretty quickly. All right, Ownership is the right to control the intellectual property. And when you get a patent, what you really get is you get the right to exclude or prevent anyone else from making, selling, using, or importing your invention. You don't necessarily get the right to make it. You may not get the right to make it because other people may own patents that you need to make your invention work. But your invention, for sure, you can prevent anyone else from using it unless they, pay you or make some other sort of arrangement. So that's what you want to get. You want to get the right to control the intellectual property in the invention or work, whether that invention is a device, a compound, a method, or for using your device or compound. We're not concerned with ownership of the physical item that embodies your invention. You're strictly talking about the ideas, the technology underneath it. Or in the case of copyright, you're talking about whatever the expressive elements of that, whatever it is you made that work, that may be. All right? So, the ownership of intellectual property in this country is created by and initially given to the first inventor or the first author by the government. In this country, we have a federal patent system. You have your patents are going to be issued by the United States Patent and Trademark Office. That's the only place you can go to get a patent. You can't go get a Tennessee patent or a Kentucky patent. It's a U.S. patent. And your patent is only good within the borders of the United States. So if you want to have a patent, if you want to be able to control the ownership of your invention anywhere other than in the United States, you're going to have to go to Canada or England or France or Germany or Korea or Japan or wherever you need to go to obtain the ownership. And I should tell you, that can be a very lengthy and expensive process, but that's what you do to obtain ownership in your patent. Copyright is a lot easier. Copyright is also federal law in this country. There is no state copyright system. There used to be one, but as of 1978, there is no longer one. And to get a copyright, you have to make an application for a patent or for a copyright and attach whatever it is you want to copyright, a copy of the work or some portion of the copy of the work. If you don't trust other people to come to the patent or to come to the Library of Congress and steal it, you only send in a portion. But nonetheless, it's two things. Fill out a form saying, I'm the author, here's my work, and here's my $35, and please copyright it. And that copyright, you have to obtain copyrights in the rest of the world just as you did before, but the expense is so much less. $35 for filing a copyright, $3,500 probably would be cheap for filing a patent in any one country. And if you're talking about foreign countries, it's thousands and thousands of dollars. So that's how you get the rights. You get them from the government, and you have to pay for it. There are other forms of intellectual property that you can use. Mostly trade secrets comes to mind. Trade secrets are not, until this last 3 or 4 months now, I can't remember when it started, but there is a federal law now of trade secrets, but there's also state law of trade secrets. And does everybody know what a trade secret is? It's some process or some combination of elements that you know that nobody else knows. I think the most famous trade secret is the Coca-Cola formula, supposedly locked up in 6 floors underground or something in Atlanta, Georgia. I don't know how truthful that is, but it's a formula they have that they don't disclose to anyone, and that's how they keep the value. And that form of trade secret differs a little bit from patents and copyright, because in patents, if you are going to get a patent from the government, you have to tell the government, and you have to tell everybody else in the world what you know about your invention. You have to be so clear about what you've got that anybody who has ordinary skill in your science or art can take your patent and make the device, make the invention, and go off and sell it if they wanted to, except the patent would stop them. Copyright's the same thing. You have to say, here's my work, and take a look at it, but it's mine. Trade secret, you go, No, nobody can see my work. I don't know that it will work out for you here in this competition, because you're going to have to explain what it is you're doing, but in your future life, if you go on to be a great entrepreneur, you also may want to consider trade secrets as another form of intellectual property protection. But a trade secret is only as good, it can last forever, but it's only as good, it's only good if you can keep it secret. That's not always easy. Given duration, I probably should talk about that. The patents are going to expire in 20 years from the time that you file your patent application. Unless, of course, the patent office screws around a lot on it, and then they add some time to you in the end. And it's a mysterious and undecipherable formula they use to decide how many more days to give you, days, months, or years to give you. But generally, it's 20 years. Copyrights last what seems like forever, but it's not. It's the life of the author and 75 years. So you can see that can be a relatively lengthy period of time as well. The old days, you had to renew your copyrights every 15, 17 years and keep doing that. But now, no, you get one term, 75 years plus the life of the author, or unless you're a corporation and you're filing for the copyright under the corporation's name, then you get, you have to 100 years, just 100 years. Nobody's life is measured. It's not measured by anybody's life. Okay. Any questions about what we talked about so far? All right. Patents, copyrights, ways to protect your intellectual property, but you have to get approval from the government. Let me just, I'll go into the process a little bit in a little bit. Okay.
So there's no sense of an international patent in regards to getting a patent like that?
There is not, but
You have to get patents per country?
there are, that's a good question. There are certain treaties that you can use to obtain partial rights. There's a treaty that says that if you file, for example, in the U.S., and you want to have an international, if you want to make if you file a form, I guess I should say, that say you're claiming the right to reserve filing in all these other states, and it doesn't cost you that much, to check the boxes and file the form and turn it in, then you have 30 or 31 months, depending on the country, in which to file in a foreign jurisdiction. So if you wanted to file in England, or you wanted to file in say you're making a drug and you want to file in Austria, then you have 30 months from the time that you file your U.S. application to start the process in that foreign jurisdiction. There's a pounding something here? Or?
It's the roof.
Oh, I thought somebody wanted to get in desperately. I couldn't imagine anybody wanting to break in to hear this, but okay. If you're there's treaties also in Europe where they have a European patent office. But once again, ultimately you have to go to that country. What the European Patent Office does is it collects the patent, it translates it into 2 languages, and it does a preliminary search, which we'll talk about in a little bit, and then says, okay, you're ready now. If you really want to do this, come on in and file your application. But copyrights, they have a treaty for that. There's an international treaty that virtually every country in the world is a part of, and it recognizes your rights. If you have a U.S. copyright, you can go to a foreign country and you can file, and nobody's going to, they're just going to say, okay, that's good, pay the money, we'll put it on file, because they assume under that treaty that if it qualified as copyright in your country, it qualifies as a copyright in the rest of the world. Maybe not always true, but it's the assumption that you get. So you have international there. But as far as patents go, no. As far as trade secrets go, I don't know that I'm qualified to speak to that, because I really don't know about the trade secrets in other countries. Okay. All right. We talked a little bit about wanting what's necessary to get a patent. Well, The first section of the patent statute says, whoever invents or discovers any new, draw lines under that, and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent therefore, subject to the conditions of the statute. Okay, well, some things you should know about this. First of all, useful is very easy. I mean, as long as you don't come in with something that you say is a perpetual motion machine, virtually anything else you can bring to them is a useful invention. As long as it falls under this machine manufacture of composition of matter, etc. Second, the new is where we start to see some problems. Let me back up just 1 second here. Go forward in the slides and back up. Section 101 right now is probably the hottest area in patent law. And I don't know that you guys will have any of your works, probably will not fall under it. But it doesn't say so in the statute, but the courts have interpreted it over the many years that what you cannot get a patent for is laws of nature or naturally occurring things. And so if you find out that dandelions can cure cancer, you can't get a patent on that because the dandelion's a natural occurring thing, and whatever powers that dandelion had are just an inherent part of nature. And so you cannot get patents on that. And that transfers down to living things and things derived from living things. Right now, the big push in biochemistry, or a big push, is to what can you do with DNA sequencing? What does it tell us, and how can we use it for beneficial purposes? And the cases in the last several years have now said that no, you cannot, because the DNA is a naturally occurring product. And whatever you do, if you're taking the genes and you're splicing them and chopping them, no matter how you're doing it, they're still the natural genes. And so there's cases that say you can't take certain gene sequences and use it as a testing method for certain conditions of ill-being. All right, it just doesn't happen. Probably one of the things that may be more germane to you, and I don't know what exactly you do, but if you're doing any software and whatnot, mathematical formulas, which of course includes algorithms, cannot be patented. In fact, software, it wasn't allowed, you weren't allowed to get patents in software until, when you get old, you think it was just happened yesterday, but it's probably a long time ago. But it wasn't that long ago. It was certainly in the 90s that we had this rush of software products and software products, especially relating to business methods. Okay, and the court originally said, okay, anything under the sun. They had a case that said anything under the sun that man can create is patentable. And then they started looking at things, especially where they were mathematical formulas really to enhance trading, stock trading in the markets that just had certain algorithms that would click in and click off to enhance the trading. And they said, well, let's rethink this. And there were some cases. There was a case that first there was a patent granted to, and I don't remember who it was. I believe it was to Amazon, about one-click shopping. They had a system where you could go in and you could make one click and buy the goods at checkout or whatever. And they got a patent on that. And people were saying, well, wait a minute. This is a method that has been around forever, and it's just it was a natural part of the business world for so long. Just because they stuck a computer in there, why should we allow the patent to take place or be granted? And so those kinds of cases were eventually eliminated. And abstract ideas is sort of the catch-all now for those kinds of patents that are business method patents. So if you're thinking about in your competition of doing something like devising a better way to do some sort of business, you should think, maybe you don't care because you don't ever want to get a patent, but if you ever did, you should be thinking about would this be allowed under Section 101, or is it one of the laws of nature, natural occurring things, or mathematical formulas that's going to knock me out from getting patent protection? Okay. Switching over to copyrights for a second, sort of in the same vein. Copyrights are granted, you get copyright protection for expressive ideas. You know, you get copyright protection, you all can understand that you get it for a movie script, or a song, or a book about World War II, or something that allows the author to be expressive and create, be expressive in creating the work. Copyrights are not for useful items. You cannot get a copyright for a useful item. So a lot of what you would be doing in here, unless it is software related, which I'll talk about in a second, unless it's software related, you probably are not going to find copyrights will be that helpful to you. Trying to think of an example. You can get a copyright, for example, on one of the famous cases was a lamp. It was a woman's shape, face or whatever, holding up, and then the lamp bulb was screwed in up here, okay? And they wanted to get a patent, or rather, I'm sorry, a copyright for the lamp. And the Copyright Office first said, well, wait a minute, it's a lamp, that's a useful item. Cannot copyright a useful item. But as time has gone by, they're now saying, well, you can get a copyright on the sculpted part of the thing. You just can't get it for, you can't prevent somebody else from doing something like that and making a lamp like that, as long as the sculpture part is not the same. And that sort of describes two problems with copyright. One is that you can't get a useful item, and the other thing is that it's fairly easy to work around. If you have a system and it's software oriented, you cannot get a copyright, just like with patents, you cannot get a copyright on the mathematical formulas. You can't get a copyright on any algorithm. So what you can get is you can get a copyright on the rest of the software, or maybe how you display things on the screen, or a number of those things, although that's even more limited now because the case law over the last 20 years has sort of chipped away at even that. But you can still get a copyright on software for the expressive items, expressive elements of your work. But you're not going to get one for the actual guts that do the work. And so anybody would be free to come in and use the same algorithm, the engine of the whole software, as long as they were able to write around it slightly, and with the rest of the part of the software product. The rest of it would be considered to be the expressive part, and if they can be expressive in a different way, you cannot protect the core of your invention. All right. Let's go back to patents for a second. By the way, any questions about the value or the ability of those kinds of laws to protect you? Okay. Let's go back to patents for a while. Remember we had the screen up before that said you get a patent if it was new and useful. Okay, and then it described a whole bunch of things kinds of things that could be claimed as patent. All right, well, first claim, or the first hurdle you have to get over in the patent situation is you have to be able to demonstrate that it's new. Those up there, that starts the clock running on the 1 year. In addition to things that are new, novelty, that are things that are brand new, you also have a situation where what you're doing is not exactly identical to what's come before, but anybody who's worked in the area should know that this would be, the next step would be this to make a better patent. You want to improve the patent that you have, and all you have to do is do this, and you've got a new patent. Well, the patent office says, well, wait a minute, if it was that obvious that what the next step should be, we're not going to grant a patent on it. And you will find that probably the leading cause of patent applications being rejected is because the invention, in the eyes of the examiner, the patent examiner, who typically is a young engineering or chemistry major, in their eyes, if it doesn't look like it would be obvious to do that, then you don't get it. One of the early examples of what would be obvious is that you all have had pencils and you had erasers on the end. Before they had that, you had your pencil and you had your eraser, and you had to erase, and then you had to go back to writing. Somebody said, well, you know what would be a great idea if we stuck the eraser, put a metal clip on the top of it and stuck it into the pencil and into the eraser, and now they're one thing. And so the patent office said, well, it's a nice invention. It's certainly good, but it really is not. It was pretty obvious that you could stick the eraser at the end of the pencil, and so you can't. won't allow you a patent. Now, to me, that would qualify because it's an improvement on what the situation was before. It takes two things, but the patent office said no. And believe me, if you don't want to try to explain the rationale on what's obvious and what's not obvious all the time, they have tests, but they're not always as clear as they might be. But it is obviousness can be a hurdle to get over with your invention. Going back to copyright again, what do you need to get the copyright? Well, you need to show that something is expressive, and you have to meet a minimum threshold for something that is creative. Do you think that well, what's minimal is often debatable, but I'll give you an example of something the Supreme Court found not creative enough lately, was the phone book. A phone book is, for years and years, the publishing companies, they would put copyrights on their phone books and prevent anybody else from making the phone book. Then somebody challenged it and said, well, wait a minute, the phone book is just a listing of names of who has telephone service, and they're listed alphabetically because otherwise it would be worthless. How would you find anything in there? And so the people who had printed this phone book says, oh, we went to all this work, it was so much work, it was so hard, and we put them in alphabetical order, and we even stuck a street address in there sometimes. The Supreme Court said, no, that's just simply factual matter. There is no expressive element to that order that you're doing, and so you cannot copyright these anymore. Then along came the Yellow Page cases, and first they adopted the same kind of standard for the Yellow Pages, but then the Supreme Court took it up and says, well, wait a minute, there is some creativity here, the way things are laid out, the colors, the way the ads read. These things have a lot more expressiveness in them, and so we won't allow you to, or we will allow you to copyright the Yellow Pages, but because it doesn't have the same comprehensive nature, lots of people can make Yellow Pages and they all have their own copyright in what they've got. The idea is there's got to be some expression. You also should know that a work can be similar to a prior work. A copyrighted work can be similar, it even can be almost identical as long as the person who made the second copy of the work was not copying from the first. You and I could stand here and take pictures. We both stand in the same place and point the camera and use the same camera and everything. And as long as we did it randomly, we could both come up with the same picture, and it would not qualify for copyright because we didn't copy. But if you copy, then that's not the case. And I guess this is what I was trying to say before, is that copyright isn't as good for what you want to do because it allows somebody to do a workaround fairly easily for whatever it is that you've got. All right, that was sort of the fast run through intellectual property. Questions? No? All ready to file the patent, or I discourage you so you'll never do it? They do have, by the way, I should tell you, if you have an invention and you think it's pretty good, but you're not really sure, and you want to take some time to perfect it a little bit more, and you want to take some time to test the marketplace, see who's interested in it, the patent statute has allows for you to obtain something called a provisional patent. A provisional patent is good for 1 year from the time that you file it. It gives you, basically, it holds your place, because if you don't go on and file the non-provisional patent, the utility patent, the final patent, then it all goes away. But for that 1 year, you get protection, and you get protection with minimal effort in filing the application, and you get the same protection for like $130 or something like that. That's all it costs to file with the patent office. So you would have a patent pending, as they say, for a low price, but you got to act on it at the end of that time, or else you lose it. Okay. We talked in the beginning about getting your intellectual property rights, so we decided that there's certain rights you're never going to get, like stuff for living matter or laws of nature and all that sort of thing. There's other patent or other protection you're going to get if you follow the rules, make the application, and your invention fits. What about? Do you have the right to do any of this in the first place? What about inventions that you make here on campus? Okay, so are you allowed to own the inventions in this come out of this course, or because it's a course, it's not yours? There's no Tennessee statute that controls the ownership. So you've got the Board of Regents right now, and Tennessee Tech can make rules that describe when you have rights in your invention. Now you may have some rights in the common law, but the rules for the board and Tennessee Tech are going to take that into consideration, at least the rules as they are written now. We have sort of an odd situation here right now. We have I'm sure you're all aware that the Board of Regents is kind of splitting up. The universities are going their own way, and they're going to have their own boards, and they're going to be able to make their own policies. That is probably not going to be effective for your purposes until November of 2018, and many of you may be long gone by November of 2018. So in the interim, you are still subject to the old Tennessee Tech rules, policies. Policies are the same as a rule or a law inside the university. You're subject to the old Tennessee Tech and to the ongoing Tennessee Board of Regents rules about when you do it. Okay, so TTU policy was number 15. It's now going to be, and it's going to be in the future, number 72. And the TBR policy is 5.01.06.00. And if there's a conflict between the two policies, which there probably won't be in your cases, then the Tennessee Board of Regents policies prevail. Okay, so we know what we got to look at to find out what our rights are. And next question, does this policy apply to students? Well, yes it does. I mean, the TBR policy says it applies to students enrolled at TBR institutions. That'd be you. So you got that. And then there's also parts of the TTU policies, the current TTU policies, that apply to you as well. And they require you to if you had, believe it or not, this has come up a few times in different schools, if you have an outside job and you want to do some, your employer wants you to do some research at the school, you better make sure that your instructor or your department chair or whoever is on board with that before you start working out of the school. And this is a TTU policy here too that talks about courses that may result in patentable or copyrightable matters. And well, it's probably not going to come up that often, but you can read it. Okay, so we know it applies to you as students. Then how about ownership? What do you own, or who can own what? Okay. Intellectual property developed by persons to whom this policy applies shall be the sole and exclusive property of the TBR institution with which the person is associated and subject to the intellectual property. In other words, unless there's some reason why that isn't true, anything that you do apparently belongs to Tennessee Tech by this policy. But they have some qualifiers here. That is something that was developed within the course of employment at the institution. If you do anything here while you are employed part-time or whatever, then you fall under the same heading as the faculty or anybody else who works at the institution, and the invention would be would belong to Tech. It was developed in the course of a sponsored project by the institution, and this is something that you all probably will be involved in at some point, or if you're not already, that is working on sponsored research, outside research. And if that's the case, then whatever you do belongs to either to Tech, or if Tech has made arrangements with the sponsor, will probably belong to the sponsor. So that doesn't help us here. Developed with significant use of the institution's facilities, services, or equipment. Significant use means the utilization of institution funds, personnel, facilities, equipment, materials, or other resources resulting in a cost to the institution, direct, indirect, or depreciative, of more than, now it'll be $3,400. It was $2,500, so it'll be $3,400 here now. So if your invention is costing Tech $3,400 under one of those categories, and those are pretty broad in some ways because of this, where is it? The funds of personnel, I don't know how, do they bill back the professor's time if he's helping you? The facilities, if there's a depreciative use of facilities, when somebody else from the outside comes in, we charge them overhead for what the people are doing. I don't know if this is going to be, this has never come up, but how does that count? Equipment, the same way. Materials, if you get materials, pretty soon you can hit that $3,400, and then you'll find that, well, maybe this invention does belong to Tech, maybe it doesn't. Something to keep in mind as you're going through it. Now, Tech doesn't have to claim your invention. The president by policy is authorized to give you back. Even if you fall under one of these things, the president is authorized to give you back the rights to your invention. And probably would do that. I shouldn't speak for him, I've never had a conversation, but it would seem logical. And then something that's developed in the course of a project arranged, administered, or controlled by the institution and sponsored by persons and agents and organizations external to the institution. That's grants. If somebody has given, the federal government gives Tech a grant to do some research, and out of a result of that research, and you work on it, and as a result of that research you come up with some kind of invention, then it would belong to Tech. And then there's a little qualifier here that talks about if you use facilities typically available to students in their educational activities, then that doesn't count towards the significant part of what doesn't count towards getting to the $3,400. Questions about any of this?
So, in regards to, well, like you said, the president having the availability to give you back your rights.
Sure.
If it's in conjunction with another agency or association, and they claim equal rights to that.
Right.
Can they have pull over the president's decision if he so chooses to refuse to give you those rights back?
Well, I would think that if some third party was involved, either by a grant or through a sponsored research contract, the issue is not going to come up. The issue, they're just going to say, hey, that's our stuff here. And only if the sponsor of the research says, no, this is not technology that we have any interest in, would they then reach the point where somebody might want to give it back to you. Okay?
I was just curious.
No, I mean, listen, if I were you, I'd be looking for every angle here if I had any good ideas, you know. And honestly, this doesn't come up very often, so I couldn't tell you exactly what anybody's position would be on any issue related to this. We've had numerous occasions where we've given inventions back to faculty members and said, yeah, go out and, you know, hopefully you can do something with this. Most of the time they don't. You go out and do something with this, but we are not interested. But I don't recall any student ever being involved. You know, maybe you'll be the first that's hopeful. We're looking for that hit, okay? We're looking for that #1 score. We're looking for something that's going to light the lights and like vitamin D. If you can, although vitamin D today probably wouldn't be patentable, but at the time it was. And Wisconsin made a fortune off of vitamin D. So come up with something simple and that'll get us a lot of money. Okay, more questions about this? This is when the university would own the intellectual property. Here's some other exceptions. If somebody is building this stuff, making this stuff, coming up with ideas without involving a significant use of university facilities or services, and sort of done it on their own time, then they would own the invention. Now, it doesn't apply to you so much, but for faculty members, we sort of take the position, or at least I take the position, which may be stronger than the school wants to, but I take the position that faculty members, we own your brain 24/7. If whatever it is you're developing or whatever it is you're trying to patent comes out of your area of expertise where you're teaching. We have had a faculty member who was just off the wall, came up with an invention that had nothing to do with what he was normally teaching. They were tired of getting the TV sets stolen out of the various computing centers and whatnot, and so he developed a new way to anchor those things down, and where it gave off an alarm before the set was even out of the wall. And he didn't teach in that area at all. It was like sociology or something like that. And so that was, we had to say, that's your invention. Go run with it. I don't know if he did or not. Okay. I don't think that scholarly works, there's an exception for scholarly works. If you write music, you create artworks, you write the next great American novel, okay, all of that is exempted from ownership claims by the university. For some reason or another, we give those people a pass. The people who aren't in the sciences or whatever, they get a pass for their scholarly works. And it says, trying to see if I know. I guess I don't have the tech one up, but the tech one's even broader for scholarly works than the TBR section is. So the idea is that we're not going to punish, or we're not going to take away inventions for some guy who can write the next great choral or novel. Oh no, your policy is consistent with this, but yes. What else was I going to say about that? Okay. Any questions about this? Okay, so you want to know whether you got it or not. You got to do a some kind of analysis. I guess just what it says. If you're not an employee, there is no university sponsorship intervention. There was not a significant use of university resources, including personnel, facility services, or equipment, and the project was not funded through a grant administered by the university. You own the invention, probably. Now, let me say something about this. The good news is now we've determined you own the invention, but you may have co-inventors, okay? And so there's first thing you want to do is you want to agree with your co-inventors as to how much of the invention each of you owns. Because if you don't do it right away, you're going to have fights, and everybody's going to think their contribution was 100%. And so I suggest you enter into some sort of an agreement with those people about that. The second thing I tell you, even if you own it, okay, you have to do what the faculty members or anybody else does, and that is you have to turn in a disclosure form so that the university can evaluate whether or not your own claim to ownership is correct. The forms are online. They come with a little one-page thing here that tells you exactly what you have to do to get patent protection if you're going through the university, or basically you still have to fill out the form. And the form is a multi-page document where you put in you talk about the invention, what it is, and why you believe it should be patented or whatnot. And then you bring it over to the Office of Research, right? And Dr. Otunier will evaluate, or have somebody evaluate the invention. Okay? Yeah, okay, so first point, the university president can decide whether or not the invention is to be kept. But the other thing you should keep in mind here is that it may not be all bad to have the university have some ownership interest or have ownership interest in it, because if the idea is a good idea, okay, or at least a good idea in the eyes of the patent and copyright committee on campus, they will pay for the patenting costs, which can be significant, very significant, and take the risk that a patent will issue. Also, the university, I wish we could say we do more, but can do some minimal amount of help in marketing the invention for you. And the university would pay you 50% of whatever they get for licensing out your invention. And if you take away all the patent costs and all the other costs that they have to go through, and the legal costs for getting the license together and all that kind of stuff, that's not a bad deal. Not a bad deal at all. Now you and your co-inventors have to split the 50%. That's why you should make that agreement about what you each own. But it's something to consider. Okay, so you got to ask the question: is it important to own the invention? Now, one of the things we didn't talk about before is that we talked about ownership as the right to exclude, but we didn't talk about the right to license things out. So you want to know from a business standpoint, I guess, and the last slide sort of gets it. From a business sense, how do you perceive ownership versus the ability to raise capital, providing a marketing edge, or the increased profit or margin, or otherwise gives you freedom to operate a business? Those are things you're going to have to weigh. There's a lot of inventions out there that are being used right now that the company that's doing the marketing, the company that's doing the sales, is merely a licensee of the person who holds the ownership rights in the patent. They maybe have an exclusive license, but they're a licensee, and so they could decide that, well, we could still fit our business plan around having an exclusive license. There are other startup operations that say, well, I'm never going to be able to raise capital unless the company owns the invention. And so you may find that that you have to sell whatever it is you did to make it work. But you need to examine those factors as well when it comes down to disposing or licensing or exploiting or marketing or doing whatever you're going to do with your patent or your copyright. Okay, anybody got any questions? No? Okay. I don't know any more. Well, I mean, I know more stuff, but you don't want to know it. It's really boring. Okay, well, thanks for coming. Good luck with your...
Just one comment though. If you are able to come up with an invention and you want to disclose it, there is a form on our website. If you just go to tennesseetech.edu and then look on the research and then look for intellectual property. There is a form, a disclosure form for you to disclose.
Right, that's the form that I was showing you before, where it's got the instructions about what to do with your invention. And
If you need any assistance, then of course we're able to help you. I'm happy that Mr. Brown is here, Jeff, and then helping you develop prototypes, that type of thing. So you have all the resources actually that you need if you wanted to move forward with any type of invention. So we help you with the protection, commercialization. It's a little bit tougher, but we can help you with all aspects of the protection that you need, whether it's a copyright or you're trying to file a provisional application or you're trying to file a utility patent. Just come talk to us and then we'll be happy to help you out.
Well, very good. Thank you so much. Let's show our appreciation to Mr. Svendsen. So again, like Mr. Antonio said, it is on the website. And if y'all have any more questions, feel free to send them to me. I'm happy to get those answers for you. And before we end, does anybody have any questions whatsoever?
Do you
Good.
want to say anything?
So just, because I hear this from all angles, right, doing what I do and the chair that I sit in, so don't pay attention to all the urban myths. I mean, I've heard students say, I come up with an idea for